Afternoon, everyone. Thanks for joining us today for our session on personal problems in the workplace. For those of you that don't know me, I'm Debbie Coyne and I'm a Senior Associate in the Employment team. I'm pleased to be joined by my colleague Leah Edwards, who also qualified this month, which I'm pleased to say, and joined our team, which is great news for us. And later on in the session, we'll also be joined as well by Vicky Sivret from our family team, who will also just discuss some ways in which the family team can add value and support for some of your employees as well, who are faced with difficult personal issues. So today's topic is personal problems in the workplace. This really does cover quite a broad range of issues. So today we're going to focus on 4 areas, which is alcohol and drugs. I'll then pass over to Leah, who will talk about childcare and carers. I will then touch on breakups and divorce, and we'll finish up with domestic violence before we pass on to Vicky. The purpose of today is just to give an overview of each topic. There are many personal problems that can arise and can impact the workplace. And I'm sure many of you have seen a significant rise in this over the last 18 months or so, particularly with the pandemic. We've certainly seen a rise in a lot of illnesses, mental health issues, bereavement, divorce, separation, just to name a few. So it really is an important time with things sort of opening back up, things hopefully trying to get back a bit more to normal, for organisations to start to look at their policies, their procedures and processes in place. So if we have a look at alcohol and drug misuse in the first place, probably actually this is possibly one of the most sort of complex of the 4 issues that we're looking at today. But one of the key points that employers do need to remember is that they do have a legal duty to protect the employee's health, safety and well-being. So it really is important for employers and line managers to look out for and recognise signs that an employee may be having personal issues and may need support. And so understanding the signs of drug and alcohol misuse may also help employers to manage health and safety risks in the workplace and be able to also support employees as well. There is a distinction between dependency issues and misconduct issues when it comes to alcohol and drug misuse. And sometimes the two can get a little bit interlinked and can be confused. Misconduct issues are generally looking at issues such as isolated occasions of drunkenness in the workplace, where perhaps employers will take a less tolerated approach, or perhaps when it's the possession of drugs as well, or dealing in the workplace. I'll be focusing today more on the dependency and addiction to drug and alcohol misuse rather than misconduct issues. Again, I think over the last 18 months, we've certainly seen a heightened use of alcohol and drug misuse because of difficult social and economic times. So just looking back over the last sort of 18 months or so, we've seen the UK's workforce with key workers working significantly long and very stressful hours in very pressurised environments, workers juggling home, childcare, work responsibilities, people working remotely where perhaps they haven't done so before, job uncertainties with furlough and redundancies. A lot of that can lead to sort of increase of stress and anxiety, and leading to people sort of maybe having a higher alcohol and drug consumption than they normally would. Obviously, the combination of these wellbeing factors, coupled with social isolation as well as financial pressures, has led to concern that more people are using drugs and alcohol as a coping mechanism. This is supported by research where CIPD found that 27% of people reported that their alcohol consumption increased as a result of the increased stresses due to COVID-19. So we're yet to see what the impact of that might be going forward as things start to open up a little bit, but certainly there has been an increase. So in terms of in the workplace, if you have got employees who may be sort of suffering from alcohol or drug misuse, what are the signs to look out for? Alcohol and drug misuse can increase problems within the workplace, and this obviously might be more difficult to tell if people are still sort of home working, you're perhaps not seeing them as often. But certainly signs to look out for may be unexplained or frequent absenteeism, changes in behaviour, unexplained dips in productivity, more accidents or near misses, particularly when they're using things like machinery, that sort of thing, performance or conduct issue, stress, illness, and poor decision making. And what are the legal obligations? Well, as I mentioned earlier, employers have a general duty under the Health and Safety at Work Act to ensure, so far as reasonably practical, the health, safety and welfare of their employees. But employees must also take reasonable care of themselves and anyone else who could be affected by them at work. Employers are obliged to take reasonable steps to ensure that employees are not acting under the influence of alcohol or drugs, as this is likely to give risk to a health and safety concern of themselves and others. And employers really should also consider what work is being done by the employees. So, for example, if employees who may have alcohol or drug issues are working with safety critical elements, then obviously particular whether or not they may need to be taken temporarily off those duties. So that may, for example, mean when they're using machinery, electrical equipment or ladders, or driving or operating and lifting equipment. Also, just on the employer's duties and legal obligations, just to point out that drugs also differ from alcohol because the use of drugs is not generally socially acceptable and is often illegal. And employers have a further obligation under the Misuse of Drugs Act of a duty of care to wider staff and society in relation to the drug use. We could just move to the next slide, please. Thank you. So how do we get the balance right in terms of looking after and supporting employees in the workplace who may be suffering with alcohol or drug misuse? I think all employers could benefit from having a policy on alcohol misuse. That doesn't necessarily have to be a standalone policy. That can be a policy which is contained within the health and safety policy, or it could be contained elsewhere within the handbook and procedures. But it's really important that businesses do have clear policies in place that prioritise genuine support for employees, that looks at employee well-being and ensures that employees are aware of the policies and the support that may be available to them. Employees are much more likely to come forward if they're aware that any concerns they have may be treated confidentially and also be taken seriously, and there will be support available for them. A good policy in relation to alcohol and drugs should set out the expectations and what is acceptable, but it also should set out consequences of contravening the policy and when misconduct may actually be an issue as well. For example, if an employer wants a rule against drinking at work, then they should set this out in the disciplinary or substance abuse policy and make the consequences of that clear. And it should also detail who the employee can go to if they have a problem and signpost internal and external support that may be available. The next bullet on the slide is the training for HR and line managers, and this really is critical. It's really important that line managers and HR know where they should be signposting their employees to be able to get help, and also that they can seek advice. And just really that line managers can look out for the signposting and maybe the key signs where employees may be struggling and they may need help. Another thing for line managers is knowing that if somebody does come to them with alcohol or drug issues, that they can speak to them and deal with them in a non-judgmental way. The other thing to just bear in mind more for all staff is addiction awareness training. Again, not just for line managers really, but for all staff. Sometimes it's actually the colleagues that work very closely with them who may be more likely to spot signs that their colleagues are struggling than the line managers, particularly if they're working with them on a day-to-day basis. So that's something to be aware of. And just really for employers to create an environment where people feel that they can ask for help, and that they feel that that will be dealt with confidentially. The other thing as well to bear in mind, if you do have issues with employees with alcohol and drug, bear in mind that you're probably likely to need GP support or occupational health support and input in relation to that, and also looking for external organisations and counselling support that may be available to them. Allowing them time off as well to be able to get expert help is another thing to bear in mind for that. And then if we can just move on to the next slide, please. So capability or misconduct. This is often sometimes a concern for employers when they are dealing with alcohol and drug misuse. So long-term alcoholism and to a lesser extent dependence on drugs are now generally treated as serious illnesses, with many employers adopting special policies allowing for time off for medical treatment and counselling. But there will be times when an employer does feel that it has no option but to dismiss an employee because they've been drinking or taking drugs. But the approach really needs to be a careful approach as to what you are dealing with and whether it actually is misconduct or one of capability. For example, capability is likely to be more diminished performance and probably long bouts of sickness absence. So a chronic abuse is resulting in diminished performance. There's a long-term absence from work. Sickness is clearly a problem. And in those cases, employers really should take reasonable steps to investigate the true medical position and the prospects of rehabilitation before deciding on whether or not the individual's employment can be continued or whether going down the sickness absence procedure. Conduct issues is usually more of an isolated act of misconduct where drugs or alcohol have been potentially then repeated acts, but less likely to be long-term sickness absences resulting. And then just looking at the Equality Act 2010, so addiction to alcohol, nicotine or other substances is not generally to be treated as amounting to an impairment for the purposes of the Equality Act 2010. So therefore, alcohol addiction in itself is not covered by the Act. But having said that, an employee may have a physical or mental impairment that does amount to a disability within the meaning of the Act, which was caused by or was caused as a result of the alcohol addiction. So, for example, a serious liver condition or a depressive illness, which may have been caused by the alcohol, may amount to a disability under the Equality Act. So therefore, in that sort of situation, if someone has a depressive illness or a liver condition, they may be considered to be disabled, notwithstanding the fact that was caused by the alcohol consumption and addiction. So therefore, the cause of the disability is not relevant. Also, the alcohol addiction could also be a symptom or a side effect of some other medical condition from which the employee is suffering, and that itself could also mount to a disability. So, for example, just on that, in the case of Martin and British Railways Board, this was a Scottish case, but in that case, the employee was dismissed when his manager thought he was drunk at work. His eyes looked glazed and his speech was slurred. And at his internal appeal, the employee told his employer that he'd not been drunk, but he was suffering from hypertension and the symptoms resembled drunkenness. His appeal was dismissed and the Employment Appeal Tribunal confirmed the tribunal's finding of unfair dismissal. Basically, in that case, the employer should have made further investigations to discover whether or not the employee's drunken state was in fact as a result of his medical condition. I'll now pass you over to Leah, who is going to look at unpaid carers and childcare.
Can we go to the next slide, please? Thank you. So this next topic relates to unpaid carers and childcare, and millions of employees provide unpaid care whilst also in employment, and there are various rights that employees in this situation can exercise. So the first bullet point on the slide relates to an employee's right to unpaid time off. And just to note at the outset, this right does not apply to workers or self-employed individuals. Employees are entitled to a reasonable amount of time off where it is necessary to make care arrangements for the provision of care for a dependent who is ill or injured. But this right doesn't actually enable the employee to take additional leave or ongoing time off to care for the dependent themselves. So, for example, if an employee's child falls ill, they could take time off to go to the doctors and to make care arrangements. However, if ongoing care is needed, employers may then ask their employees to take annual leave or parental leave if they need to look after their dependent for longer. There's no actual set amount of time that's allowed off for unpaid leave. This all depends on the situation at hand. And there is no statutory right to be paid for this time off, but an employer may decide to pay this at its discretion. And finally, in relation to this unpaid time off, we recommend that this right should be clearly set out in an employee handbook or contract of employment. The policy should set the precise circumstances in which the employee may take unpaid time off to care for their dependents, along with any evidence that the employer may require, the notification procedures to be followed, and any penalties for abusing that right. An employee who is also a carer or has childcare commitments may make a request for flexible working. As a result of COVID, flexible working is becoming increasingly common, and it is expected that this will continue even after the restrictions are fully eased. Requests for flexible working can be made to change somebody's hours of work, the times the employee is required to work, or changes to the employee's workplace, which would include remote working. Flexible working requests can be made by employees with at least 26 weeks continuous employment. However, employers can still consider flexible working requests from employees with less than 26 weeks continuous employment at its discretion. But it's also worth noting that there is an ongoing government consultation on flexible working, and the government is currently considering whether to remove the requirement that employees must have worked for at least 26 weeks before being able to make a flexible working request. So it's just worth keeping an eye out on how that progresses. And finally, employers can consider making changes on a permanent or a flexible basis to see what suits both the company and the employee. And the final point on this slide relates to the care and leave consultation. In March 2020, the government announced proposals to introduce a new right for employees with caring responsibilities to be able to take a week's unpaid leave per year. A public consultation on this proposed new right closed in August last year, and the government's response is still awaited. So again, something to keep an eye out for. Can we go to the next slide, please? The last slide discussed employees' rights in relation to unpaid care and childcare, but this slide applies specifically to childcare. So an option for those with childcare responsibilities would be for eligible employees to take parental leave. Parental leave is available to both birth and adoptive parents, and also to anybody who has or expects to have parental responsibility for a child. And this right applies in respect of each child. So for example, an employee with one qualifying child may normally take 18 weeks leave, but an employee with 2 children would be entitled to take 36 weeks in total. Any parental leave must be taken before the child's 18th birthday. And whilst taking parental leave, employees will continue to benefit from certain contractual rights and obligations during the period of parental leave absence. For example, they will continue to accrue their annual leave. And finally, employees also have the right to return to the same job, or in certain cases, a suitable alternative job after the expiry of their leave. Could we go to the next slide, please? This slide just covers some risks to employers if they fail to exercise the rights that unpaid carers and those who have childcare responsibilities have. So there are various risks to employers if they fail to effectively deal with flexible working requests, and we have detailed a few of those here. The first bullet point, is that an employee can bring a claim if they make a statutory application for flexible working, but this was refused due to a procedural failure. The next risk is that of discrimination. Women typically still have greater caring and childcare arrangements. Therefore, inflexible policies which place women at a disadvantage may amount to indirect discrimination unless the decision can be objectively justified and it is proportionate. There are also risks of associative discrimination. For an example, if an employee is treated less favourably because they have a disabled child. And it's also worth noting that there is no qualifying length of employment requirement to bring a claim for discrimination in the Employment Tribunal. This is a day one right, so any decisions taken from the outset of employment, you should always bear in mind potential discrimination risks. And the final risk on this slide is automatic unfair dismissal. And an employee is automatically treated as having been unfairly dismissed if the reason or principal reason for their dismissal is connected with the fact that the employee took or sought to take parental leave. There have been a few recent cases relating to this topic and where the claimant was successfully awarded compensation from their employers. And a recent case is Mrs. Thompson and Scan Crown Limited. This case has been in the news a lot recently, and the claimant was awarded just short of £185,000 in compensation as a result of indirect sex discrimination. So just to give a bit of background to this case, whilst Mrs. Thompson was on maternity leave, she explored a flexible working arrangement on her return to work. She raised both informal and formal flexible working requests, whereby she was seeking a 4-day working week. She also asked her employer if it was possible for her to finish work at 5 p.m. as opposed to her usual 6 p.m. finish so that she could collect her daughter from nursery, but her request was rejected. The employer claimed that the business could not afford for Mrs. Thompson to work part-time and that the request would have a detrimental effect on meeting customer demand. It's also alleged that for continuity purposes, clients expect consistency in the sales manager that they deal with, meaning that it would not be suitable to recruit additional staff to cover her reduced working hours. All of her claims are rejected apart from her claim for indirect sex discrimination, and this is how the damages came about. It was held that a requirement to work until 6 p.m. each day placed Mrs. Thompson at a disadvantage, and she would not be able to collect her daughter from nursery in time. It was also held that the difficulty of making adjustments as to who would pick up Mrs. Thomas's workload did not outweigh the discriminatory impact on her. And I think this case just highlights the importance of properly considering flexible working requests. And as I've just said, there is no length of employment requirement to bring a claim for discrimination. So our advice would therefore be to carefully consider all requests for flexible working, irrespective of the length of service. I'll pass you back to Debbie now so she can cover domestic violence. Oh, sorry, apologies. Breakups and divorce.
We were swapping there, Leah. Okay, so just moving on to breakups and divorce. Obviously, ending a relationship, whether that's a marital one or a partnership, is a very emotional time. And sometimes it's hard to leave your personal life outside of work. Again, the last 18 months, I think probably our family team can maybe say more about that, but I think we've probably seen perhaps more breakups and divorces and people struggling a little bit more over the last 18 months with the tough challenges people have faced and suddenly having to work at home together and things like that, and obviously with the social impact. So the first thing that employers need to be aware of if their employee is going through a breakup of divorce is that they may actually require some extra support during this time, whether that just be checking in with them, checking that they're okay, checking that they're able to carry on as normal. But it's important that if you see that your employee is struggling, that you're compassionate, that you're not necessarily invasive, but ask them what you might be able to do to assist them. Their motivation may dip. It may dip for a number of weeks. It may dip in and out from day to day. So they may have heightened emotions. And it's really important that employers tread carefully during that time. It may be that you're able to offer some sort of counselling. You may have sort of employee assistance programs or other thing that you can offer that can be provided through occupational health or through a health benefit scheme. And if you do have that, point employees towards that. There may also be helplines that they can use as well. I think the other thing to bear in mind is flexible working. Obviously, this comes in a lot, and Leah's just talked about that in line with childcare and caring responsibilities. But actually, employees going through breakups and divorce, they may actually need time off to go to court. They may be going through family law proceedings. They may have mediation. They may need a lot more flexibility around the hours they can work. And obviously, they may be able to take holidays for that. That might not always be possible as well. And also, court proceedings will have a financial cost as well to them. That's likely to add further stress and burden to them as well. If an employee lives with their partner, there may be house financial arrangements that they need to also look into. Again, all of this just adds on to the stress and further costs that they may have, add to the anxiety and have an impact on them in how they may be functioning in the workplace. So again, it's just really sort of being there for your staff, being sort of compassionate in the circumstances and speaking to them about what you may be able to do, offer some flexible arrangements during that time. Also, we do get sometimes where breakups can be between colleagues as well who work in the same workplace. This can actually cause additional conflict within the workplace and impact colleagues as well. Further issue is that obviously they're going to see each other, which again may be difficult. So in those cases, it may be prudent to sit down with those individuals and speak to them about what assistance you can provide and how you may be able to assist so that things don't get worse within the workplace. Could you just move on to the next slide, please? Thank you. And just an example of that, there is actually a case of Miss Kay Bacon and Advanced Fire Solutions Limited, where Mrs. Bacon and her ex-husband worked for Advanced Fire Solutions. After announcing their separation, Mrs. Bacon was subjected to less favourable treatment by Mr. Bacon and the MD. She faced disciplinary proceedings and was then dismissed over an unfounded allegation of IT misuse. And the tribunal unanimously concluded that the MD had intentionally distanced himself from Mrs. Bacon following a separation, and that he took Mr. Bacon's side as well in doing so. So it's just an example there, if you do have individuals that do work together, where things can really, really escalate in the workplace, where there has been sort of a marital or partnership or relationship breakdown. And in that case, the employee was found to be a victim of marital discrimination. If we could just move on, please. Thank you. So I think the main thing really that I wanted to touch on when it comes to sort of breakup and divorce in the workplace is just some top tips really, is be compassionate and supportive, encourage people around you to do the same. It'll not only give your employees confidence to approach you with any struggles, but it'll also give you the ability also to spot any warning signs. We're also not just with flexible arrangements as well. You know, a lot of people have been able to work from home. That might not work for every business, but it may be in these situations, it might be something to bear in mind if the job enables them to do so, particularly if they're having a particularly hard day. Make an effort to check in with them, whether it's by email, by phone, popping down the office to see them. Just check in with them, reassure the employee, make sure that they're doing okay, and if anything else may be needed to support them. Do make sure that you do maintain boundaries. So obviously it's important to be supportive, But what you do need to make sure is that you are their manager as opposed to being their therapist. And it's just trying to get that fine line between those. Be realistic and accurate in insurances given. Don't make promises to employees that actually you can't keep. It's really important that if you are making promises to employees, what you can do to support them, that you actually check the company policies, that it allows you to be able to do those. So, for example, if you're offering extra time off or alternative work arrangements, is that in line with the policies? Are you treating them consistently with other people? And also to ensure that you maintain confidentiality at all times. Okay, I'll now pass you back over to Leah, who will talk about domestic violence.
Thanks, Debbie. So the final topic for this session covers domestic violence. And although domestic abuse may occur in the home, its impact may stretch into other aspects of the victims' lives, including their working life. The government has recently released a report on how domestic violence affects the workplace, and it reported that as many as 1 in 5 victims may need to take time off work because of abuse. And the government is currently consulting on steps which can be taken for victims of domestic abuse, and it will consult on making flexible working the default position unless employers have good reasons not to do so. Could we go to the next slide, please? Thanks. So some top tips for dealing with domestic violence in the workplace include being able to recognise the signs first and foremost. This could be anything, and it will vary on person to person, but it's being aware of how employees are and how they behave so you can spot changes in them. And signs may include unexplained injuries, decreased productivity or enthusiasm, frequent lateness or absence, and changes in their behaviour. The employee may also change the way they dress. For example, they may wear excessive clothing on hot days, and they may wear an increased amount of makeup. The next tip is to react and respond appropriately. As I think we've repeated several times throughout this presentation, you should be supportive in your approach with the employee, but remember, you're not a counsellor or a doctor, and you should point the employee in the right direction for professional help, even if they don't want it. So this help could be in the form of an employee assistance programme, if that's something that you have in place. And if you do refer the employee for assistance, you should make sure that you follow up with them on a regular basis to keep up to date and to offer any additional support. You could ask the employee about the best way to keep in contact with them. For example, which communication methods are private and which they have easy access to. We've discussed it a few times, but you could consider flexible working, and the flexible working may differ in the short term and the longer term to allow the employee to deal with this problem. You could share domestic abuse helpline posters in physical and virtual spaces, such as on the back of toilet doors and on the intranet. You may also wish to implement a domestic abuse policy that addresses confidentiality. We suggest that confidentiality should be maintained wherever possible. However, there are some instances where confidentiality may have to be broken, for example, where there are concerns about safeguarding children or vulnerable adults. And the final point that we want to quickly touch on is record keeping. So we suggest that you keep records of any support offered to the individual, and that you should also keep a record of any incidents of abuse in the workplace, including, for example, persistent telephone calls, emails, or visits to the workplace, or any concerns that the employee reports. You may also wish to record anything that occurs around the workplace, such as during travelling to and from work, or meetings not held in the usual place of work. Could we go to the next slide, please? So just to conclude the presentation, this slide includes some generic tips for dealing with personal problems in the workplace. The first bullet point refers to employee assistance programmes. So the help provided under each programme will obviously differ from employer to employer, but it may include an initial helpline which employees can access. It may also offer specialist counselling services. We suggest that you familiarise yourself with what the programme offers, and where appropriate, employers should be reminded about such supports. Managers should be trained to spot the signs of various issues, and they should know who to go to if further support is required. employers may wish to nominate wellbeing champions and mental health first aiders, but it is important that if you do this, if somebody is nominated to undertake this role, they should receive specific training to do so. It may be appropriate to refer the individual to occupational health, especially if this would help to facilitate their return to work. And finally, I think this is relevant for everything we've discussed today, we suggest that you update any relevant policies and procedures. And even though this sounds very obvious, you should ensure that all staff are aware of such policies and the support available. You shouldn't just have policies in place and assume that employees know about them. You should provide appropriate training and raise awareness accordingly. So that concludes everything that we need to discuss from an employment perspective. So I'm just going to hand you over to Vic, who's a senior associate in our family team. And I think Vic will just quickly cover how the family team may be able to help.
Thank you. Yeah, hi, I'm Vicky Sivrit, and as the slide suggests, I'm a senior associate in our family law department. I'm not going to keep you long, so don't worry, because I know it might feel like we're going slightly off topic. But what you might see is clearly the issues that have been raised and discussed today are all very much firmly within the areas of law that we as a team deal with every day. So the main thing with family law issues is, of course, they can affect anybody at any time. Anything that's been discussed today in relation to drug and alcohol issues, any kind of family breakdown, childcare arrangements, separations, all of these issues, domestic abuse, are things that we as a family team cover, obviously from a slightly different side to the employment team. So I'm sure lots of you know our employment team and know that you're in safe hands with them if you need to come to them for any more information or advice in relation to things that have been discussed today. And I'm here just to simply tell you a little bit about us as a family law department and where we might fit in to help you or any of your employees at any time. We do have a big team across our 4 offices. So we have Chester, Shrewsbury, Manchester, and we're just shortly opening a Wirral office, so we can accommodate discrete meetings with any clients at any time, whether that's over the phone. I know lots of people prefer, of course, video calls at the moment, but we are offering in-person meetings as well, and we can arrange those as and when needed. We do cover all full range of family law issues, so whether that's in relation to, it's not just family breakdowns, there's also things like prenuptial agreements and those types of issues. But where it falls to you really as employers is not only just to be recognising those signs of distress and issues within your employees, but to think about on a practical basis how you might be able to help them. So you've had here from Leah and Debbie lots of tips and pointers in terms of your legal obligations to think about for your employees, but there is also a practical side that you can think about, which might be to steer them in the right direction and make sure that they are getting that legal support, as well as their other options for support such as counselling and their GP, etc. And sometimes I think particularly with family law, it's the type of legal problem that people really like to have a face to a name and a really highly recommended person that they know that they can send their friend or their colleague or their employee along to see somebody that you know that they're going to be in safe hands and well looked after. That's definitely something we would support, obviously on an individual personal basis, offering those initial discussions. Sometimes people like to just have an initial chat just to see what options they might have, whether they're doing the right or the wrong thing, particularly when they're right in the thick of an initial family breakdown or childcare arrangements or a domestic abuse situation. So all of those things can be handled. Another slightly different angle to think about that some of our other clients have thought about previously is you as employers offering as a perk to your employees a package that you might be able to offer them the support or the contact to us to come and have that additional advice. So it can help you because it perhaps might mean that your employee is able to get themselves back into a more supported position, and they're going to be therefore perhaps an employee that's going to be more productive for you, and that's going to help you, but also you can put them in the right place for their support. So that's something we can also consider, that other corporate clients of ours have done previously, where they might, for example, say we have an association there and a partner solicitors. you can offer perhaps an initial meeting with us where you might support or supplement those costs to your employee as a perk to them. So that's something that we would definitely be open to discussing with anybody on an individual basis. And of course, it goes without saying, because I think for some employees it might be a concern for them that it would be completely discreet and obviously completely confidential, so they would still be treated as an individual client with us, and it's not that you would be part of any of those discussions as their employer. So it's something just to think about from another angle, and if there's ever any queries from that side anybody needs, you know where to find us through our employment team or direct to us.
Thank you, Vicky. I don't know if anybody has any questions at all. Obviously, we're happy to take any if you want to sort of raise a hand or put them in messaging. Otherwise, if anybody does want to contact us afterwards, then please feel free to do so. I think there is just a final slide, actually, which I'll just mention is our upcoming event, which we've got an employment law masterclass looking into hybrid working, which is on the 6th of October. And the details are on the slide there if anybody is interested in that and would like to book onto that. Otherwise, unless anybody does have any questions, then just want to say thank you for attending today. No. No, I don't think there's any questions. So thank you, everybody. Hope to see you soon. Thank you.